Start the ball rolling this morning. I just want to say that what we're about to talk about today, contractor versus employee. We had a change of government last week. Based on what we already know, it's very unlikely what we're going to talk about today will change. So if there's any expectation that the incoming government are going to make some changes, make our lives easier, unfortunately I don't think that's the case. So I do apologise that we can't have some improvements, but I doubt that would happen in the first term. Second thing I'd like to suggest to you is that if you've heard me speak before, you'll know that I'm not the sort of person that's going to be telling you what to do. What we're going to do is inform you about what we would suggest or recommend that you do, keep you informed about what we think the issues are, and then you get to go away and make those decisions yourself. If you'd like to take a significant risk, that's your call. The other thing is, I'm a little bit disappointed. I see the two tallest guys in the room here, Lex and Brad, have got their collars on, and I haven't. So I'm clearly not as cool as they are, but I do. Maybe I should put it up and I wouldn't bet. Okay. There's no doubt in my mind that the changes that have occurred in the last 3 to 5 years in terms of legislation and regulation have made it very tough for all of us. And those of you that have heard me speak before about fair work issues or workplace health and safety, today's issues are no different. They just don't make it any easier for us. So what we have to do is try to come to grips with understanding it, and I'm not quite sure how the legislators expect us to all know or expect business owners to know, but there's some guru down in Canberra, I think, that thinks that we all just magically have all the answers. Be that as it may, we're stuck with what we've got and we do the best we can. The complexities of this issue are quite involved, and there have already been several court cases where the courts have made determinations about what they think represents or makes up an employee or makes up a contractor. Because the issues are a little bit complex, what I'm going to do is I'm going to separate today's presentation into 4 sections for you. The first thing I'm going to do is try to explain to you why some businesses prefer to engage workers as contractors. And there are reasons why you might have a preference for wanting to do that, so I'll explain those to you. As a part and parcel of following on from that, we're going to explain to you what the risks and the penalties are if you get it wrong. Now what I mean by that is if you engage as a contractor when you should have engaged as an employee. The reverse is not a problem. If you employ or engage as as an employee, and later on you found out that they could have been a contractor, there are no problems. It's only in the situation where if you engage them as a contractor and they should have been an employee that you've got the issues. So we're going to talk about the risks and the penalties for getting it wrong. So that's the second thing. The third thing we're going to talk about are what are the factors or what are the issues that help you decide or determine if they are in fact a contractor or an employee. And Sarah's going to cover that with you. Last but not least, we're going to go through the steps that you probably should follow if you engage a contractor or if you engage them as an employee. So once you've made the determination about whether or not they're going to be an employee or a contractor, then you go through the steps and the process to engage them. I just want to mention a couple of things to you. There was just 2 scenarios that have come up, been quite relevant or prevalent, and I want to explain them to you so you know where you stand. I'm an employer, I'm looking for a worker, and the worker walks in the door. He might be a fencing contractor, it might be a harvester, it might be a plumber, it doesn't really matter. But he says to you, I want to work for you, I'll do that work for you, I've got my own ABN, I'm a contractor. And you say, great, that suits me down to the ground. I get to avoid all the hassles. He wants to be a contractor. He's got his ABN. Away we go. From today's session, I'm hoping you come to the realisation that is wrong. Just because he says, I've got an ABN, just because you're happy with the deal, he's happy with the deal, you shake on the deal, does not make him a contractor. And if something goes wrong or blows up, we'll talk about that later, maybe in question time, I can assure you, the fact that you had a mutual arrangement, the fact that he was happy and you were happy, won't matter. Those risks and penalties will come into play. The second issue is this one. We had a client walk in the door here one day and he said, no problem at all, the person's a contractor. And I know it's a good deal, I know he's a contractor because I went to a solicitor and I got the solicitor to draw up a contractor's agreement, which he signed and I signed. We're hunky-dory. And I know it's good because the solicitor did it. Wrong. What he didn't say is what he told the solicitor. He went to the solicitor and said, draw me up a contractor's agreement, which the solicitor did. And they both signed it. But that, just because they both signed a contractor's agreement, and the solicitor drew up an agreement, the agreement itself might be good, might have been a good agreement for a contractor's agreement, but it doesn't make that contractor or worker a contractor. Don't be misled into believing that because we're all happy with the deal that it's okay. It's not. Just read you a couple of comments I had come out of a report the other day, and it wasn't to do with contractors and employees, but it was some comments made by farmers. And they're good comments, and I certainly concur with them. But they don't make it right for the legislation we're operating in. This particular farmer said, people should be responsible for their own actions. It shouldn't always be about blaming the boss when something goes wrong. And I'm sure everybody in the room agrees that that's how it should be. But that's not how it is. The legislators have made it damn near impossible for us. They've legislated to the point where common sense doesn't matter. The worker has certain rights. And it's your problem, whether you like it or you don't. Another farmer said you can't legislate for common sense. He was inferring that everybody should use a bit of common sense. And I agree, they should. But in reality, that's not what happens. Okay, so that's what we talked about before. So why do we want to engage as contractors? First, why do we want to engage contractors? Well, first and foremost, it's easy. It's simple. He walks in the door, says I've got an ABN, you give him the task to do, you agree that he's going to submit an invoice at the end of the week or at the end of the month, and Bob's your auntie, you're done. Hardly any administration, you don't have to worry about too much. You probably should be thinking about whether or not you should be deducting some tax if he is a contractor, depending on what's in the agreement. You may have work cover issues and you may have super issues, but as a general rule, that's about it. So there is less administration. It's less costly. There's less time. On the other side of the coin, if you engage an employee, you've got all the hassles that go with it. What sort of an engagement is it going to be? Are they going to be permanent? Are they going to be part-time? Are they going to be casual? What award are they on? What rate are you going to pay them? Do I have to do up an employment contract? What are my workplace health and safety issues? What about the unfair dismissal laws? What happens if they don't perform? Like, it's a nightmare. So I can understand employers wanting to engage as contractors. There's no doubt in my mind that life would be a lot simpler. A couple of the other things I haven't mentioned is that employees, you've got payroll issues, you've got payroll processing to worry about, and you've got all the regulations that apply to employees that you have to consider. I guess probably the next thing that's involved with contractors and employees is that a contractor is supposed to bear the risk. Now what I mean by that is you engage a contractor, simple one is a fencing contractor or step pole or whatever, they do something wrong. In your agreement, your contractor's agreement, they are responsible for getting the job right. So if they stuff up, in their agreement, you should have provision there, they've got to rectify the stuff up at their cost. If you have an employee and they make a stuff up, the employer bears the cost. And it's a double whammy. You're going to pay them wages for the next time round whilst they're doing the work, let alone the cost of fixing up the stuff. So there is significant risk in terms of engaging workers as employees versus being a contractor. So, I'll hold this up so I don't want to listen. So what are the risks, or what are the penalties if you get it wrong? In the first instance, if you engage as a contractor and they turn out to be an employee, you could very well be liable for paying back PAYG tax. So if you haven't deducted the tax, you might have to pay all the tax that should have been deducted. If they get classified as an employee, you might have to turn around and pay all the superannuation guarantee payments, superannuation guarantee levy. Depending on the hours they've done, depending on how long they've worked for you, depending on what the arrangement was, you might have back pay to pay, you might have penalty rates to pay, you might have allowances to pay. And depending on how big your organisation is, you might even have payroll tax to pay. And then aside from all of that, if you've got it wrong and they turn out to be an employee, you're then going to be subjected to all the employment law issues to do with fair work and the awards. And in particular, that might lead to the unfair dismissal laws, the adverse action laws, payment of annual leave, payment of personal leave, work cover, redundancy if they've been dismissed, and possibly significant fines. So what I've presented to you so far in the last 15 minutes is giving you this picture that it's certainly easier or better and more time efficient and less costly if you engage as a contractor. But if you get it wrong and you engage them as a contractor when they should have been an employee, there are significant risks and penalties. And they are very far-reaching. Some of the cases we've read, admittedly, look, some of them are larger organisations, but some of them have cost hundreds of thousands of dollars. So you don't want to get it wrong. And the challenge is that if you do get it wrong, once they're on your doorstep, once they're investigating you, they'll go through everything. They won't just stop at that. They'll keep going. Okay. Going to hand over to Sarah. I'm not very good at getting that going. Okay, so I'm going to hand over to Sarah, and she's going to tell you how you decide. Now, just hasten to add, there will be time for questions at the end of this session, and if you do have any queries, just write them down and we'll go through them after that. I'll be back shortly.
Okay, so I'm here to let you know how you're supposed to assess a worker to decide whether they're a contractor or an employee. And the biggest thing about this is there's no one single factor that will determine the relationship. There's a whole host of characteristics that you should go through and assess. So tick off if they're an employee on that side but they're a contractor on this side, and assess it on the whole situation. And the thing is that if you engage someone and you decide, you can't hear me. Oh, this is a problem I seem to have. If you engage someone and you give them a contractor's agreement and you decide that you haven't fundamentally changed the relationship. So as Barry was saying, you've simply labelled the relationship wrongly if they are in fact an employee. And they also use the terminology called sham contracting. And there are penalties involved in that if you've deliberately or recklessly engaged an employee as a contractor when you know that they're an employee. That would come under when you have initially engaged them as an employee and decide to swap them over to a contractor. That would come under that. Okay, so these are a few of the factors that you need to consider. One is the control over work. So this is whether you have the ability to control the worker in fine detail. So an example would be if you have a delivery truck driver and you say they need to make deliveries between 9 and 10 a.m, do these deliveries Monday, Tuesday, Wednesday, and they have to take specific rest breaks and you request them to submit a logbook, that's more inclined to be an employee because you're significantly controlling the way in which they operate as a truck driver. Whereas if you engage a truck driver and say between the 24th and the 1st of December, 24th of November and the 1st of December, you need to deliver to this area, doesn't matter what time of day you deliver on, they have the responsibility of looking after their logbooks, and when they actually deliver things, then that's more inclined to be a contractor because you're not micromanaging them as such. The ability to subcontract delegate, this is more in line with if you engage a worker and they can't show up for work that day, do they have the ability to send someone else in their place without checking for you? So if I call a plumber into my place and say, can you please fix this pipe on Tuesday, and they happen to be sick, but they have the ability to send someone else in their place, then that's a contractor. Whereas if I engage someone to do a job, if you have a musterer and they're sick but they can't send anyone else in their place, that's leaning towards being an employee. The thing to remember with these is when I'm saying it's leaning towards it being an employee or a contractor, you have to go through each of these together and at the end create a tally. So even though one may have a big influence on the outcome, you can't just say, oh well, they had the ability to send someone else in their place. So that's basis of payment. This is one of the easiest ones to manipulate because, as Barry was saying, if you say, oh well, I've got an ABN, just submit an invoice, it doesn't fundamentally change the relationship. It just means that they're then submitting an invoice rather than being paid as an employee. This is where you would be agreeing on completing a job as a whole, rather than say being paid per hour per item. So, but this is one of the easiest ones to manipulate. And the thing is that even if you submit an invoice, it becomes insignificant if all the other factors are leaning towards it being an employee. Equipment, tools and other assets. So this is where whether the worker supplies their own tools or equipment or whether they're supplied by the employer. So if the business tools are all supplied by the business, then it would lean towards being an employee. If the worker supplies their own tools, but the business reimburses them or they get an allowance, that could also lean towards being an employee because the worker is not really out of pocket for supplying those tools. But if the individual supplies a majority of those tools and they are a significant investment on his part, then it's leaning towards being a contractor. There was a case came through the courts. It was through the unfair dismissal courts, because what they do is they say if something goes wrong, the employee will lodge an unfair dismissal claim, and the courts will have to decide firstly whether they're a contractor or employee. If they're an employee, then they get the unfair dismissal rules. The case that came through was a trucking company, and there was three employees that were alleging they were actually employees, not contractors. And the outcome of the case was that they were actually contractors. And one of the main decisions was that they were providing their own trucks, which was a major source of investment for the individuals, and that was an influencing factor. But the judge did consider all the other characteristics as well. Another one with that is whether they are required to wear their own uniforms. So whether the business requires the individual to wear the company uniforms. So the next one is commercial risk. So if the worker takes significant commercial risk, so if they muck up the job, or they get it wrong, or they have to go back and fix it, and it's on them to fix it and their time and money, that would lean to be towards a contractor. But if the business is responsible if they muck it up, then that's leaning towards being an employee, because the worker has no responsibility in terms of financial loss. Independence. That's where you're operating, whether you're operating exclusively as a business. So this goes towards whether you're advertising your services to the world at large. So if the worker is providing only services for the company, this one's a bit, you have to assess it on the individual situation. But generally, if the worker has like a business card, they're advertising, they're purporting themselves out to the general public as operating under a business, and they're offering their services to other companies, then you're leaning towards a contractor in that situation. Whereas if the employee is if the worker is just engaged by the one business, and they're only working for that business, but still under a contracting arrangement, then that's leaning towards an employee. So generally, an employee the work is controlled by the employer. They work the hours directed by the employer. They generally don't they have no financial risk. They're entitled to superannuation. They're entitled to the modern award provisions, leave provisions. They have PAYG taken from their pay. They're paid regularly. And the thing is that with leave and things like that, the absence of being paid those doesn't necessarily mean that they're a contractor. It just means that the situation hasn't been truly recognised as what it is. Independent contractors, on the other hand, usually decide how and when they work. They decide whether they can delegate the work to others or send someone in their place. They carry their own risk of making a profit. So they pay their own GST, PAYG, super. There are certain exceptions for that one. They have their own insurance, and they're generally responsible for how their business operates and what jobs they can and cannot accept. And they generally submit an invoice for what they work. So one of the key messages from this session, that's not my slide. So one of the key messages from this session, and basically what we usually refer to when we're telling people that if they come up to us and, is this person a contractor or an employee, it's called the duck test. And it goes, if it waddles like a duck, quacks like a duck, looks like a duck, even if it was brought up by penguins and it thinks it's a penguin, it's still a duck. You can't change that fact. No matter how much you want to, it's still going to be a duck. And the other thing is, if you're always trying to justify why an individual is a contractor and you're thinking, oh, it's got to be this, or there's this, this and this going for it, and you're trying to justify it and there's some level of doubt, we would suggest it's worth getting it looked at. And if there's still some level of doubt, it's always a good idea to engage as an employee, because the risk is a lot less onerous. So if you have that level of doubt, I'd get it looked at, and if it's not stacking up, then it'd pay to see whether it actually is an employee rather than a contractor. And as Barry alluded to, the penalties for getting it wrong are quite significant, not in terms of penalties as fines, but even just in back pay and things like that. So it is quite an important topic of conversation. So I think I'll hand it back over to Barry to go through the final bit.
Okay. One of the really, really, really important messages from what Sarah's told you is to don't look at any one of those factors in isolation. She did allude to that. Just because they've got an ABN doesn't make them a contractor. Just because they provide their own tools doesn't make them a contractor. Just because you've decided they might take some significant risk doesn't make them a contractor. It's the entire picture that is used to make the determination. All of those factors are considered. No single one does it. One might, in the end game, one factor might tip it over the line to be a contractor or an employee. But don't be misguided into believing one factor. Oh, that's okay, that makes him an employee, or that's okay, that makes him a contractor. Because that will be a misguided perception. Okay, so what do I do? First thing you need to do when you decide you need a worker, one way or the other, you decide what the job is that you want done as a business owner, as an employer. How do I want it done? What do I expect from the job? You go through the issues, consider the issues, and I'm guessing most of you in here are here because there are times when you think you might want to engage a contractor. So you think about all those issues and you make a determination. I'm going to engage as a contractor, or I'm going to engage the worker as an employee. Now, a really good one, I see Trevor's in the room here, Trevor Nimmo. And I don't know how Trevor runs his business, but he might have carpet layers that use their own tools. And I'm not asking Trevor, I don't want to know, but that's a good one, because mechanics are the same. Quite often mechanics provide all their own tools and go to work. So the question in those employers' minds is, are they contractors or are they employees? And the short answer is you would go to all those factors to make your determination, not just the fact that they're providing their own tools. So back to this. So what do I do? So employee, first of all, you've decided, okay, they're an employee. You have to work out what type of arrangement it is. Are they going to be permanent full-time, permanent part-time, or casual? You have to work out, are they covered by an award? What rate am I going to pay them? You have to consider what hours, what overtime, what penalty rates may or may not apply. Am I going to give them a salary? What am I going to do? What are the WHS issues? And they're important, more than ever right now. You would then normally go ahead and prepare an employment contract, and then you would have some sort of plan in terms of what the arrangement will be in terms of the employee, what rules they're going to abide by, job descriptions, all that sort of stuff. As a contractor, you would check out, have they got all their own tools and the equipment that they need? Do they have the appropriate licenses? Do they have the appropriate insurance in place? Public liability, professional indemnity if it's needed. Work cover for themselves. insurance for disability, all that sort of stuff. You would, or I would recommend, you should have a proper contractor's agreement drawn up. Now that's probably one of the biggest failings I see. Employers come in here and there's no contractor's agreement. So really you haven't got a leg to stand on before you even start if you don't. In that contractor's agreement you would specify what the work or works to be done are. You would specify what rate you're going to pay them, whether it's including or excluding GST, what the payment arrangements would be, and any other terms of engagement that you think are relevant for the work to be completed. As I said there, check insurance. You would make sure whether or not that the contractor can fulfil the obligations that you want them to fulfil, or can they delegate the responsibility to one of their own workers. And you would certainly make sure that they have the appropriate workplace health and safety qualifications and policies and procedures in place for workplace health and safety for themselves. I think that is about it.